Welcome back to Sunrise Daily. Well, yes, we're keeping our focus on the elections, but this time the judiciary. We do remember that the chairman of INEC raised some concerns last time out about over 600 cases concerning electoral matters before the courts, meaning there is a huge role for the courts. And in recognition of that, there's election petition tribunals, which is in line with the provisions of the Constitution to set up that tribunal at least 30 days before the elections, and that has been done. So, and remember the CJN did issue some caution to those judges saying, look, as the Chief Justice of Nigeria, he went on to say that he will not condone any act of recklessness, abuse of power, and public trust. He did urge them to discharge their onerous responsibilities with honesty, integrity, and transparency. He asked them to do what is right in the law books, and they will have their names etched in gold, and that if they do what is at variance with their conscience, they will get a scar that will terminally dent their ascension to greater heights. That's the CJN admonishing judges, and 307 of them will be presiding over election petition cases. We do have two gentlemen joining us this morning to weigh in on some of these matters. Mr. Victor Okwara joins us virtually. He is a senior advocate of Nigeria. And here in our studios, we've got Mr. Adebayo Ojo, who is a senior advocate of Nigeria designate and former Attorney General and Commissioner for Justice for Oyo State. Good morning, gentlemen. Thank you for joining us on the program today.
Good morning, and thanks for having me.
All right.
Good morning.
Mr. Okwara, let me start with you. There's huge expectations from the public, I dare say, concerning this matter. We time and again hear cases being decided in the courts. Politicians can thump their chests sometimes, say, yeah, we will get to the courts and have our way. But in view of the concerns and the expectations raised from the bench, and those expectations from members of the public, does it come across to you as though perhaps this time around, with a lot of focus on the judiciary, we should expect justices, I beg your pardon, judgments, decisions that will really and truly meet what you say, that justice should not just be done, but will be seen to have been done?
Well, Chairman, thank you so much. I want to say with respect that I want to say that the judiciary has a very important role to play, particularly as regards pre-election litigation and post-election litigation. And I'll start by saying that the CJN and all the justices and all the judges who are saddled with responsibility, I'm very sure are not unaware of the onerous duty thrust on them to dispense even-handed justice. Having said this, when it comes to delivering electoral or pre-electoral judgments, judges don't just act at large. They are circumscribed by the provisions of the law. And what is this provision of law? You're looking at the Electoral Act, you're looking at the political party constitution, you're looking at the constitution itself, and you're looking at decided case authorities from where these judges will drink from. I'm talking of intellectually and professionally to dispense justice. Now, if you look at the concerns being raised by several people that the judiciary could pander to the wishes of the electorate, of the politicians, to a large extent, I do not share that view. And this is because there is a provision of the Electoral Act 2022, which is certainly going to be tested in this new dispensation. And with the constitution of the election petition members, you will notice that even the CJN admonished them that he was not going to tolerate or condone recklessness, whilst admitting that there's going to be tirade, there's going to be campaigns of calumny. But most of all these judges themselves are trained, and I'm sure, I have no doubt in my mind, that the President of the Court of Appeal, whose duty it is to constitute this panel. And if you know very well, the President of the Court of Appeal is a person of impeccable judicial character who knows our onions. And I say this unpatronizingly and with all sense of responsibility. I certainly believe that these judges and justices are going to dispense justice the way it ought to be. Now, it is not out of place for there to be some reservations about the extent to which these judges will go. And of course, it is not out of place to feel that, oh, judges are humans. And you must understand the fact that there is, like I said, there is a filtration process. With the tribunal, it's not the end of it. Depending on the category or the cadre of aspirants, of either aspirants or people who feel aggrieved by a particular election, there is an appeal mechanism as well. So I believe, with the greatest respect, that the provision of the Constitution, the Electoral Act itself, will to a large extent contain the judges. Let me give you a practical example now. You see, under the Electoral Act now, for example, the court cannot, with the greatest respect, stop the conduct of a primary election or stop the conduct of a general election pending the examination of a suit. So clearly there is a statutory intervention that has taken place to ensure that that will not come to play. Secondly, there is another provision in the Constitution itself that does not even allow the court to declare a person a winner of an election if you do not show that you participated in all stages of those elections. So it is not something to say that, oh, yes, we can have our day in court, or at the end of the day, we can get our own. It's not as easy as that. And most of the mistakes of the past have now been corrected by statutory intervention. I'm talking of the Electoral Act, which is 2022. And of course, provisions, even in the Constitution, to right the wrongs or the mistakes of the past. You know, we are in a democracy. And of course, you understand that as the thing is evolving and these statutes are being tested, the Constitution is being tested, areas that need to be fine-tuned will be fine-tuned. So I want to believe with a great respect that this time around, the judiciary will get it right. And of course, you should know that this is a court of duty. And every particular judgment or electoral tribunal's judgment will be subject to scrutiny. Scrutiny by the public, scrutiny by the aspirants or the contestants, scrutiny by the plaintiffs or the defendants, and of course, scrutiny by the appellate courts. You don't want to be a part of a panel that will give a judgment and the judgment goes on appeal and you'll be lampooned seriously. Not only will it affect your judicial integrity, it will actually affect your vertical rise going through the judicial rank of the ladder. So basically, it is not only something you need to do, and of course, you need to have the fear of God. And Nigerians are becoming more politically sophisticated. And you know very well the electors are becoming more politically sophisticated. Everybody is talking about this 2023 election, having regard to where we are today as Nigerians and the state of governance today. So everybody wants a change. I'm sure even if you pick a little child there, everybody's interested in what will happen in 2023. And of course, with the swearing in of this the electoral panel, the electoral judges that will be saddled with responsibility of dealing with post-election matters, and seriously so, and with the admonition of the CJN and all the follow-up seminars and workshops to actually bring them in tune with the reality of today, and to keep our best of the innovations of the Electoral Act, coupled with the fact that the finest of benefits have been brought forward to deal with this issue. I sincerely believe that the judiciary will get it right this time. And of course, don't forget, there are disciplinary processes.
Yeah,
there are disciplinary processes.
We'll look at those provisions soon. But let me bring in Mr. Ojo here. I mean, there are some interesting cases and scenarios that had played out before now and will still play out in view of the hundreds of cases before the court about election matters. I mean, that of Adamawa, we've seen that, recently Akwa Ibom. We've also seen several other states. I mean, Ebonyi too was quite interesting, several perspectives on that matter. So different states just looking to see even Taraba at the moment. So, and some of these persons have expressed reservations on this matter as they, in a manner of speaking, think that the authorities seem to have descended into the arena in the way those judgments came. You've been in close quarters with politicians because you served in the government. So from what you've seen now, given how all of this, do you subscribe to perhaps those who think, wait a minute, this also has a huge role to play with parties in terms of them getting their internal democracy right? Because if that is not strengthened, I mean, you will always have these cases in courts.
Thank you so much. Political parties must get their internal arrangement very right. And you know, we've come a long way because it has checkered history. Starting with Meko, that's former governor of the state, and Alliance for Democracy, Ade Guruye and Edi. As at that time, the court, their decision was that, even up to the Supreme Court, that those are matters within forum domesticum or political party, that they lie and end with whatever the political party may decide as they deem fit. But now we've gone ahead. We've moved away from that. The court has now said, look, you must comply with your own constitution and guideline regarding how you regulate your affairs, that is political party. And also, you must comply with the Electoral Act. Apart from complying only with your own domestic affairs, which have to do with your guidelines and political party, you also have to comply only mutandis with the Electoral Act. And finally, because we are in a constitutional democracy, we are not just in a democracy, but we are in a constitutional democracy, you must comply and adhere strictly, absolutely, with the Constitution of the Federal Republic of Nigeria. So the issue of that something lie within your domestic capacity is no longer the law. So you must, all those three important and vital documents that are itemized must be complied with. So we've moved away. And look, let me say this. I listened to Mr. Mike Guinea when I was coming here. I also listened to my learned senior, Opara SCN. Look, I listened to this CGN too, and all, but I don't agree with all of them.
Why?
I'm a politician. Political parties can get it, politicians and political parties can get it wrong. Because politics itself is about conflict and result of conflict. You can't say that politicians won't play rough because all sorts of people are in political parties. We have the good, the bad, the ugly. And you can't expect them to behave the same way. There must be conflict. And there must be a series of what I would call strife, like you have in Akwa Ibom, even in your state. And you see it's not limited to any political party. It's cut across in APC, in PDP, and even in Labour. You can see what is going on. But the most important organ in the democracy is the judiciary. Not that judiciary have an important role to play. It's the most important organ. Look, why do we have judiciary? It is to regulate and place all of us where we belong to.
Yes, but a lot of people will say that you cannot burden the judiciary because it is a regulator with matters that political parties themselves should ordinarily be able to regulate.
That's lame excuse. That's what me say is idle.
Yeah,
let me explain.
Just a moment. I mean, I was actually going somewhere with that line of thought. First and foremost, we've seen that this is like a, will I say, a martial force that has now been set up by the judiciary to be able to tackle the backlog of cases. This is going to have consequences for regular cases that are in the courts. But the judiciary says that it is saddled with over 600 of these pre-election matters, as the case is, you know, and it knows it quickly has to dispense of them. This is costing time
and resources.
Of course, to be able to do it. So shouldn't we also be placing a burden on our politicians to conduct themselves in such a manner? And some people will say that it is not impossible to be more mature, because we say our democracy is young. But, you know, there needs to be ways, mechanisms, and that's one, I guess, one of the reasons we keep taking the Electoral Act back for amendment every time, so that our conduct is done in such a way that, you know, politicians can conduct themselves in a more mature manner to reduce the plethora of cases we're seeing in the courts?
What is young in our democracy? We started in 1999, and was that our first experience? Our first experience was in the First Republic.
So you make my case that we are growing,
let me make my point.
Let me make my point.
Let me make my point. Then we had the Second Republic, 79 to 83. We had the third one. Then this is the fourth, if I don't mistake. If I don't make a mistake.
Republic,
this is the Fourth Republic.
Yes.
So what is young in it? But the issue is this. Look, let every arm of government play its role. What are they there for? They are to resolve conflict. If they are now saying politicians should regulate themselves, yes, I agree they should behave decently and more maturely. But no, it is made up of, it's a rainbow coalition, all sorts. You have 4 manners of people there. And you see, I won't blame them. I won't blame the politicians. Because people like you and me, we refuse to participate. And if we refuse to participate, we cannot blame those who are there. Decent men and women are very few among them. So that's why we are saying political, it's a murky water of politics. Why is it murky? Well, look, let me make my point. When you and me refuse to participate, look at in advanced democracy, look at US, look at Canada, look at UK. Who are there? Professionals, lawyers, journalists, accountants, all those people. You only find people like we have here in their own political setting. And let me give you an example. When 2015 election was coming, my principal, Senator Abdulaziz, was about to run for second time. He now said, all of us, because in his government, 80% of us we were technocrats, professional in politics, as opposed to professional politicians. Now said, look, all of you should forget about this, or there you are technocrat. Go back to your local government. Go back to your ward. Go and join them and participate. I went to my local government. I'm from the Southeast local government. Then when I got there, they welcomed me. They were happy to see me. Dapo Lamadesina, who later became House of Rep member, took me along because his father was a former governor and Dapo was a politician. When they saw me, they were happy. And they introduced me to all members of the ESCO. He said, this is the chairman, this is the vice chairman, this is the secretary. Then they said, and this is the legal advisor. I know the legal advisor. He was my uncle. He's dead now. I said, but Luku, when do you become a legal advisor? But Luku is not a lawyer. They call him Luku Lega. And he said, I said, OJ, what do you mean? Did we see any lawyer here? But Luku did not even have school certificate. But when they couldn't find any, they have to improvise him and make him a legal advisor. Because we are not there. That's the problem we have all over the country.
Okay, but
what are we talking about?
What I want to ask right now is, looking at what the judiciary has had to do in this instance. First, are you satisfied? Do you think that, what do you think would come out of it? Is this a dangerous precedent in your own? Because if you say that politicians, it is within their right to take as many cases as they want to take to court, and they can saddle the judiciary. That's
let it be 1,000 cases, 1,000 or million.
That is well within their right. But look at what the judiciary has had to do to be able to solve the problems that it currently has on its hands. What is your own thinking of this? Will I say, is it innovation that the judiciary has had to come up with?
I don't agree with innovation. We had Second Republic, and I want to propose that there should be a return to the election presidential regime of the Second Republic. Look, Sagari, Awolowo went to court against Sagari, and that case was decided before Sagari was sworn in. How did it happen? The court of first instance was at the court of appeal. Then it was decided. They went to the Supreme Court, and it was also decided before they were sworn in. And we had several governorship petitions too. No judge will come from a Kano state. What we have now is a sort of all sort and mix up. They will bring somebody from a Kano, somebody from Akwa Ibom, another one from Yobe, another from Eswia, to come and decide electoral cases in Oyo State. Why? In the Second Republic, judges of Oyo State dealt with Igano lawyer. They dealt with Akinde did not go to court when he lost Bolege. And the matters were determined. The first five, the most senior judges of the state will constitute the gubernatorial election tribunal. Then you go to Court of Appeal. Then you go to Supreme Court. Oh, look, when you now bring all these strangers to come to my state, they make all sorts of money.
Strangers?
They are strangers. When you bring somebody from Akwa Ibom, you bring somebody from Yobe to come and decide.
But they're matters of law.
Let me make my point. And to come to your state to decide. And they do whatever they can do, and they run away. Immediately, no. I've been a participant since 1999, when it happened. You see, immediately after judgment, they will escort them out with security men, and they leave the state under security cover. Look, let it be assigned to judges on ground. Let them take bribe. Let them take bribe and decide the judgment the way they like. See, they are living with us. They know they are within the state. They won't do it.
There's so many things coming up from what you're saying now. Wait, does that then suggest that? Because, I mean, you all say that when these judgments are given, it goes down in history. Their name goes down in history, either for good or for bad. So if there are those highly placed judicial officers, shouldn't they know that? Did they actually consider, or is that a huge consideration, whether or not somebody is resident in the state you give judgment?
Let me tell you. You see, we've lost our values in this country, and we must face that fact. In your sector also, not only judiciary, even in your own constituency, the media, in the banking sector. If you go to a bank now, use your ATM. The highest you can get in other banks' ATM is 10,000 naira. If you press 20, it won't come out. Then CBN said, it's only after the third withdrawal that you charge me 65 naira if I'm using other banks' ATM. But right from the first one, they will charge me 65 naira for withdrawing 10,000 naira. And I may need 100,000 naira. That means 10 times 65 naira times 10. A lot of money.
But you can challenge it.
No, you can challenge it. How long will it take you to challenge it? And let me now say, what will be the cost? The cost of challenging it will be higher than the amount you are withdrawing. And what do you see now? You will now see POS point, all these money trading points. Who owns them? They are bankers. So and look at academics, look at ASU. So the entire value system of this country is gone. And we need reset. And I tell people, what's in the rat? What's the constitution? Look, I've seen the constitution of the United States. It's a small pamphlet. You get my point? And our constitution is big. We've amended it. We are now at the fourth iteration. We are working on the fifth one. Is it about the law, about the constitution? It is not. It's about ourselves. Like William Shakespeare said in the Judicial, the fourth, dear Brutus, is not in our star. But in ourselves, we are the underlining. Let them bring the best of constitution for us. Until we are ready to purge ourselves and make ourselves better person, we make mess of whatever document we have. Is that
to suggest that as things are presently constituted, we cannot expect the best of standards from the judiciary?
No, forget the judiciary. Are they angels? Are they not? Which judiciary? Are they United Kingdom judiciary or they are Nigerian judiciary, like Nigerian lawyers? What? Look, I'm a lawyer, and I've been practicing law since from 1993. I have over 30 years experience now. What I see that my colleagues do in court, it is appalling. We are just religious. We are not God-fearing. We are not godly. Look, they can't do 1/10 of we do here in UK or even in Kenya or in Ghana. They lose their license, but there's no regulation here. Likewise, judiciary too. You see, I listen to the CJN. I sympathize with him because I know him very well. Very honest, judex of impeccable integrity. Because I know Judge Ariwola very well. You see, but the problem we have on our hands are greater than what any CJN or whatever can do, unless we all decide. But look, we all say the country is not, all of us will come here on the television, Nigeria is not good. Why is Nigeria not good? Is it, who are the operators? Look, play your part. Let me and my family do what is right. You and your family do what is right. Let everyone do it. Then Nigeria will be good. That's just it.
All right, let's bring in Ms. Okpara again on this one. Ms. Okpara, look, listening to him, it's not a very good picture, but it did identify what can be done to salvage the situation. And we did ask, does it mean that we can't expect the best of the judiciary? You were making a point about we having disciplinary committee or arm of the judiciary who are expected to play certain roles. But at the moment, if we rely on what Mr. Ojo has said, isn't that going to be tantamount to putting something on nothing, as you say in law?
Well, thank you so much. I'm of a different legal, of course, because I want to say with the greatest respect that the judiciary operates in this same country. So you cannot, technically speaking, divorce the judiciary from the myriad of problems and the plethora of issues affecting Nigeria as a country. But I must tell you the truth. One of the ways to win in line the politicians is to ensure that the judiciary wields the big stick. And if you look at the judgments that have been emanating from our court so far, you will see some of those judgments as you see, the politicians themselves, as it were, would always want to outdo themselves. And that's the judiciary. And that's why you have the judiciary that needs to interpret the law as it is. And it is not, I don't want to paint a big picture. I don't share to a large extent, with respect to the stand the TSN designates, I don't share some of his views. Because if you look at it very, very well, one of the best ways to cage politicians is to ensure that when they start or perpetrate this political by the time they begin to see that, look, if we do A, B, C, and this thing gets to the court and is litigated properly, and we afforded even-handed justice, all those nefarious activities.
Yeah, but Mr. Okpara, if I could just ask you, doesn't it, I mean, there's bound to be conflict of ideas as well here, so there's nothing wrong with having conflict of ideas, but isn't it being realistic when he says, look, the immunity, if he suggests the immunity of the judiciary to certain corrupt practices or tendencies has waned, and we have to be realistic to call a spade and not an agricultural implement?
I didn't get you. Come again. I didn't get that.
Well, Mr. Joe suggests that if we're right from what he says, that the immunity of the judiciary to corrupt tendencies or corruption has waned, and we need to be realistic about approaching some of these matters as opposed to playing the ostrich.
Well, I'm not aware of this immunity he's talking about. I know that there is no constitutional immunity for judges. I know very well that there is a constitutional mechanism for dealing with erring judges. And these provisions, you can see the provision of the Constitution as it were. So it is not a case of immunity. It is a case of an established procedure for dealing with those cadre of people because of the sensitive role they play. I'm not aware that any judge or justice who is reckless or who is very corrupt has any immunity.
Yeah, but Mr. Okpara, in this same country, we've seen judges that have judgments that have been handed down, and citizens of those states clearly don't agree with those judgments till date. In fact, many of them say that the courts now seem to be taking up the roles of the electorate by taking certain decisions that don't go down well with the populace, in the manner of speaking, foisting political office holders on the people.
Well, the courts are courts of justice, not courts of public opinion. That the judgment should go a particular way. The court has to adhere selfishly to the wishes of the majority of the public. Every judge is confronted with facts and law before that particular judge. So if in the course of ventilating your rights before a court, you probably or you don't even afford the court of substantial project evidence to prove your case, what do you want the courts to do? Is the court going to manufacture evidence? And of course, any judge or justice that panders to the wishes of the public in arriving at a decision needs to be questioned.
Okay.
You are supposed to, on the of the law, the provisions of the pleadings of the parties, and bring justice to bear, having regard to the way you see it, benchmark against case law, statutory law, and of course, the question as it were. There is no over judgment that it will be beneficial or attractive to everybody. Well, of course, that's why in law we say fair justicia, right? Can let justice be done in heaven's form. And of course, if you have a judgment handed down by a court and you are dissatisfied, Then you can take vertical proceedings, which is going on.
All right.
And the justices that will look at.
Okay,
yes.
Let's bring in Ms. Ojo on this one. I mean, yes, you've given a picture from your experience, from what you've seen, and that's perhaps we all need to see things from some perspective, why they will have somebody who is not anywhere near being a lawyer, being a legal advisor of a political party or a group or an association, and then that's why we see some things go the way they go internally. But isn't there any silver lining in this matter?
The silver lining is this. I said, let everybody play his role the way it should be. We don't even need the Constitution. We all know what is right. Like when they asked Jesus Christ, they said, Rabbi, which was the greatest of all the law? He said, love your neighbor as you love yourself. If I love you, I won't do anything untoward, or even sleep with your wife, or harm your children. We all know what is right. And let me correct an impression. I didn't talk about immunity. But what I'm trying to say is this. Look, politics is all about conflict. And there must be resolution of conflict. That's the basic. Then who resolve the conflict? It's the judiciary. You resolve. Look, in the time past, what we used to know is that electoral matters, you cannot commence it by way of urgent summons, that it had to be by way of petitions or by way of writ of summons. We've all been put wrong now with the electoral, what do we call it now? The partition issued by the Chief Judge of Federal Court, Justice Ho. We are not doing by urgent summons. You file your affidavit, I file my current affidavit. In a litigation, we cannot all be on the same pedestal. Our roles must conflict. The plaintiff, I'm not happy with your declaration as a candidate to my party, or I'm not happy with INEC declaring you as the winner of that election. And I go to court. We don't expect the two of us to be added them on our point. We must conflict. We must conflict. And that conflict that we presented, somebody must resolve it. And that person is the judiciary, which judiciary must do in accordance with the oath of office, which they subscribe to. You see, who is the most powerful arm of all the three arms of government? It's the judiciary. The President Buhari today, as the Commander-in-Chief of the Armed Forces and what have you, cannot order anybody to be killed or to be taken away and put in jail. But judiciary has the power to do that. I can be sentenced to death, and that person will be executed. Look at Kanu. He's been there for how many years or months now? Because judiciary said, keep him there, not the federal government. If the president cannot keep anybody there indefinitely, we go to court by way of a habeas corpus proceeding, produce him before the court, and the court will have to declare his rights, set him free. So that's to tell you that the most potent of all the three is judiciary. And what are we now talking about? Once a judex, look, there's a difference between justice and judgment. That's the mistake my learned senior is making. You can give judgment. Judgment, a court, any court will deliver a judgment.
But if it's not seen
yes,
by the people.
But if you deliver justice, even from the loser, I should be able to walk away from the court satisfied and happy that I've gotten justice.
You know, when you give the analogy that different sectors of society, they have challenges of people, corrupt persons in different professions, that's what we're trying to refer to.
All over.
Those immune to corruption seem to have waned, and so every sector is affected, and something must be done about it. That's the analogy we're trying to make at that one.
Okay, I agree with you.
But we have to draw the curtains for this segment at this stage, gentlemen. But there's something that will always keep in focus. We'll have less than 100 days now to the big day, the election. So we'll always call on both of you, Mr. Victor Okpara, Senior Advocate of Nigeria, and Mr. Adebayo Ojo, Senior Advocate of Nigeria Designator, former Attorney General and Commissioner for Justice for Oyo State. Gentlemen, thank you both for coming on today.
Thank you for having me.
Thank you very much. I appreciate it.